All rise, veuillez vous lever. Please be seated. Veuillez vous asseoir.
Ms. Dimitri, you have the floor.
Thank you, Mr. President. Your Honors, the prosecution has asked this chamber to impose a total sentence of 22 years of imprisonment on Mr. Yekatom if convicted. The common legal representative of victims of the other crimes proposed 30 years for the charged crimes, excluding the alleged conscription, enlistment, and use of child soldiers. And for this specific crime, count 29, the common legal representative of victims of the alleged child soldiers has suggested a separate term of 20 years, without substantiating it in his brief, even less so yesterday, as he spent almost of his allocated time wrongly claiming that the registry would not have asked nor made copies of identity cards of defense witnesses under 68.2 when conducting certifications. While we recognize that sentences must be individualized, without the benefit of guidelines or charts, such as in domestic jurisdictions, the fairness and the appropriateness of any sentence imposed must naturally be measured against the sentences imposed in this court. And this is what serves as a barometer, providing an objective framework of comparison and not national jurisdictions. And that's why we respectfully ask Your Honors to ignore the prosecution's comparison yesterday, where he referred Your Honors to life imprisonment sentences imposed by national jurisdictions for a single murder. And obviously there has to be a cutoff point. And the central question then is where the facts of Mr. Yekatom's case fit along this barometer of sentences imposed by this court. And Your Honors have had the unique advantage of first-hand experience with the facts of various cases adjudicated by this court. And we ask that you draw upon this context to assess whether the alleged acts and conduct attributed to Mr. Yekatom, even when taken at their highest, warrant sentences comparable to or exceeding those meted out to other accused individuals who have stood before this court and even before Your Honors. And I want to now turn specifically to the common legal representative of victims of the other crimes and their request for a total sentence of 30 years of imprisonment against Mr. Yekatom. And I start by this one because it's the highest. This figure represents the maximum years of imprisonment provided by the statute. And the justification for this request, as outlined in their brief, appears to rely heavily on the views of victims. And according to their submission, this figure stems directly from suggestions made by individual victims. And more concerningly, however, the CLRV2 further justifies this figure by pointing to the outcome of unrelated cases, asserting in their brief that previous acquittals or withdrawals of charges in other car-related cases have left victims unable to achieve justice or have their victimization recognized in a court of law. And they repeated it yesterday by saying that the victims have not obtained justice for crimes committed in car for decades due to its history of violence and cycle of violence. And this reasoning by the common legal representative of victims of other crimes unfairly attempts to conflate the frustration of victims in entirely separate cases, cases in which Mr. Yekatom had no involvement. it cannot be overlooked that the proposed term of 30 years of imprisonment mirrors the sentence imposed in the Ntaganda case. And yet, your honors are well aware that sentencing must remain individualized, grounded in the specific facts and circumstances of the case at hand. And it would be, in our respectful submission, inappropriate to equate the actions and alleged culpability of Mr. Yekatom directly with those in the Ntaganda case without a thorough, reasoned comparison with that case. So let's look at the facts in Ntaganda and for which Mr. Ntaganda was convicted of. It's a case, of course, and your honors know it better than I do, where Mr. Ntaganda was convicted for his direct role, the direct role he played in the commission of numerous crimes. His role in personally, and again, not through the actions of others, him personally, killing and shooting Abbé Bwanalonga, a Catholic priest abducted by the UPC FPLC forces. The murders attributed to Mr. Ntaganda occurred on a shocking scale, with over 100 confirmed victims, according to the trial judgment. And the chamber made findings of murders of unquantified numbers of persons and found that the scale of the crime of murder to be large, and made specific findings that killings were said to be carried out regularly and repeatedly across 2 operations, targeting men, women, children, the elderly, and even hospital patients. A case where the targeting of civilians was found by the trial chamber to be relentless, with no hope of their return to their villages, whereby findings to the effect that attackers are said to have conducted searches from house to house, seeking out the Hema civilians, where civilians were called and hunted out from their hiding place in the bush, only to be slaughtered, where homes were shelled or torched across 8 different villages. A case where Mr. Ntaganda was found to have personally recruited UPC and FPLC fighters, including child soldiers, and then proceeded to rape and sexually assault those closest to him, including his own female bodyguards. These acts were committed in full knowledge of or encouraged the broader pattern of sexual assault and slavery inflicted upon victims of the UPC FPLC. And this level of gravity, the sheer scale, and the personal culpability of Mr. Ntaganda in the trial judgment as a direct perpetrator are in no way comparable to the allegations Mr. Yekatom is facing. First, the range of crimes are broader in Ntaganda. There are, of course, no allegations against Mr. Yekatom concerning crimes of sexual gender-based violence, nor are there any claims of pillaging or destruction of the adversary property against Mr. Yekatom. Second, the scale and the modus operandi of the murders in Ntaganda, which warranted a 30-year sentence for both crime against humanity and war crime of murder, are vastly different. While Mr. Yekatom faced charges of related to 20 murders, evidence was not presented for each and every alleged killing. Nor is it alleged that these were murder victims who were pursued by Mr. Yekatom, lured out of hiding, nor subject to abduction, sexual violence, and execution. Third, the terms of forcible transfer or displacement, in which Mr. Ntaganda attracted sentences of 10 and 8 years respectively, the facts here are entirely different. There is no evidence of houses being burnt or essential goods looted to prevent populations from returning. To the contrary, and you heard Ms. Baysat, who highlighted, Mr. Yekatom took concrete steps to facilitate the return of the Muslim populations to their homes. And moreover, and contrary to the insinuations from yesterday, the defense did not diminish the gravity of forcible transfer or displacement in its written submissions by highlighting the fact that some victims had returned to their homes. This is a continuous crime, and as I said, there has to be a cutoff point when assessing the gravity of offenses. So a situation where victims of forcible transfer can never return to their home because it no longer exists is objectively of more gravity to cases where victims did return to their villages and where their homes were still standing. And finally, Mr. Yekatom is not alleged to have been a direct perpetrator. The prosecution already walked back its case on this point in relation to the Yanwara school incident. All allegations pertain to Mr. Yekatom's role relate to him as an indirect co-perpetrator or an indirect perpetrator, the degree of participation which Mr. Pagès-Granier has already addressed. Now that I'm done with the 30 years imprisonment sentence proposed by the victims of other crime, I want to turn to the prosecution's proposal of 22 years sentence. This too is disproportionate and flawed. The prosecution's argument is based on an ambiguous global assessment of the accused's anticipated culpability. At times, the prosecution uses the same underlying facts as both evidence of gravity and as aggravating factors, despite their disclaimer in footnote 10 of their sentencing brief. Just yesterday, the prosecution told you that the position of authority allegedly occupied by Mr. Yekatom was an element of the offense and therefore not an aggravating factor, circumstance, despite then submitting that Mr. Yekatom did abuse his power as a FACA personnel. And similarly, the prosecution wants your honors to count discriminatory intent as an aggravating factor, when the underlying discrimination, that is against the Muslim population, forms part of the contextual element of the offense in relation to the alleged criminal policy and the alleged criminal plan, and the elements of the alleged modes of liability. And again, contrary to what was implied yesterday, our written submissions did not intend and do not, in fact, diminish the suffering of victims. The fact that a factor is relevant for gravity purposes should not be considered for aggravating purposes is a procedural protection. And additionally, the prosecution's claim that a 22-year sentence reflects the purpose underpinning the court's sentencing regime is unconvincing, even when they attempt to compare and rely on other cases, such as Ongwen. Again, a case your honors have first-hand knowledge of. In Ongwen, it was concluded that the joint sentence of 25 years, inter alia, and I quote, adequately reflects the strongest condemnation by the international community of the crimes committed by Dominic Ongwen and acknowledges the great harm and suffering caused to the victims, as well as deterring others from committing similar crimes in the future and discouraging Dominic Ongwen's own recidivism, end of quote. And the prosecution explicitly refers to this in their brief to justify its recommendation of 22 years against Mr. Yekatom. And of course, the court is concerned with serious crimes, which are internationally condemned, and it's a given for all cases before the ICC. But the point is whether the term imposed adequately reflects the culpable conduct for which is subject to condemnation and reflects the suffering of the victims and adequately serves as a deterrent. In Ongwen, that term of 25 years, and this is only 3 years more than what the prosecution is suggesting against Mr. Yekatom. And I hasten to add, the proposed sentence of 22 years against Mr. Yekatom is 2 more years than what the prosecution had originally proposed against Mr. Ongwen. So to suggest that the case against Mr. Yekatom attracts the same or similar condemnation as those seen in Ongwen is, to put it mildly, untenable. The facts in the Ongwen case concerned 4 distinct attacks on camps whereby thousands of already internally displaced persons resided, persons who had very little in this world, following decades of conflict across northern Uganda. And such attacks were found by the trial chamber to have resulted in the killing and or attempted murder of hundreds of civilians, many of whom, including children, elderly, and pregnant women, were killed in the course of escaping. Others were killed while trying to hide in their homes, with numerous factual findings in relation to incidents whereby a number of huts in which civilians crowded together were bolted shut and torched with the civilians inside, where civilians who were locked into houses and burned to death. Others were found to have been killed for their refusal to carry goods looted by the attackers. It's a case where the chamber made findings involving the systematic abduction, enslavement, and torture of hundreds of civilians, the majority of whom forcibly put to work, forced to carry injured LRA fighters and heavy items looted from camps. And sometimes, while they were tied together, over long distances and periods, extending months after months, all while under the constant threat of beatings or death for being too slow or for dropping items at their peril, with the identifiable and proven long-term injuries. Mr. Ongwen himself was found by the trial chamber to have been personally involved in specific abductions and giving direct orders for victims to carry heavy looted items, and personally instructed them not to drop items looted by the LRA as these victims were carrying them before him, in front of him. And other abductees were found to have been forced to kill one another or watch killings. And in relation to a number of mothers forced to abandon their children by the roadside or thrown in the bush, as the young children were deemed to be slowing down their carrying of looted goods. The Ongwen case, and again, Your Honors, you know it better than I do, it's a case that's also concerned the conviction of crimes of abduction and sexual enslavement of hundreds of women and girls who were then integrated into the Sinya Brigade and made to serve as domestic servants. 7 of these girls and women were found by the trial chamber to have been forced, under strict threats and heavy guard, to become Mr. Ongwen's wives and servants, and obliged to have sex with him and bear his children for months and years at a time, right upon his arrest and transfer to this court. One such finding concerns a victim that was 7 years old when abducted and 12 years old when she was found to have been forcibly married to Mr. Ongwen. Convictions of rape, sexual slavery, sexual violence, forced pregnancy, and forced marriage, all related to the direct conduct of Mr. Ongwen, as well as acts conducted by others and attributable to him. And so, Your Honors, similarly to the Ntaganda case, the Ongwen case presents clear, distinguishing features from the facts against Mr. Yekatom. This is not a situation where Mr. Yekatom, or any individuals whose acts might be attributable to him, engaged in crimes such as rape, enslavement, forced marriage, or forced impregnation of young girls and women over an extended period of time. Nor are there any allegations of pillaging, of destruction of property, or outrages upon personal dignity. The case against Mr. Yekatom does not involve murders that reached anywhere the 3 digits, nor does it involve the intentional targeting of fleeing victims. And furthermore, even taking the allegation against Mr. Yekatom at their highest, this is not a situation involving torture or cruel treatment inflicted upon hundreds of victims over extended period of time. Importantly, in Ongwen, the maximum individual sentence was 20 years, and the joint sentence was adjusted to 25 years to account for the breadth and gravity of those distinct convictions. By contrast, the case before you centers on 3 specific crime bases, each of which is limited in time, in place, and in scope of victimization. And I will now turn, Your Honors, to the last request you heard yesterday, the request of 20 years of imprisonment by a common legal representative of the alleged former child soldiers. While he acknowledges that any sentence imposed on Mr. Yekatom must, in principle, align with comparable sentences handed down to other convicted persons before this court, it falls short of adhering to these principles in its proposed 20-year term for count 29. His proposed sentence is equal to the sentence imposed on Dominic Ongwen for 2 counts of conscription of child soldiers, and it's higher than any sentence imposed under Article 8.2e, Roman 7, in other cases before this court. First, for instance, in Ntaganda, an 18-year sentence was imposed, and in Lubanga, a joint sentence of 14 years was handed down for the 3 counts involving conscription, enlistment, and use of child soldiers. It is important to emphasize that all of these 3 cases involved a violent campaign and the mass recruitment of child soldiers who were subsequently subjected to systematic brutality and cruel treatment. These circumstances are materially distinct from the facts alleged against Mr. Yekatom, and they must be considered when determining an appropriate sentence in this case. In Lubanga, for instance, Your Honors will recall the magnitude of child soldiers in this case, whereby quite literally thousands of children were found to be abducted by the UPC and FPLC forces, and then actively used in hostilities in a systematic manner. And it is important to consider the factual distinctions between this case and that of Lubanga. Mr. Lubanga was convicted for his personal and his direct involvement in the recruitment of children, including his public speeches to local populations encouraging children to join the forces. Mr. Ntaganda, a sentence of 18 years was imposed in relation to a case where there was an orchestrated campaign to conscript child soldiers, with families who were targeted and who were threatened to hand over their children, and where Mr. Ntaganda is said to have personally made calls for parents to hand over their children, and where he then selected several of which to become his own personal escort. A case where child soldiers were then actively used in hostilities, including their engagement in active fightings, all of which took place, according to the trial judgment, over a period of 17 months. And finally, in Ongwen, a sentence of 20 years imposed in a case where columns of children under 15 years were abducted and then integrated into the Signa Brigade, with Mr. Ongwen convicted for his direct and personal involvement in the abduction and the distribution of boys and girls within his own units. This was, of course, whereby the recruitment was a design of the LRA modus operandi, with a systematic kidnapping of children, relentless condition which ensured their obedience over a period of 3 years. So it must be emphasized that the facts against Mr. Yekatom, even if we accept the CLRV1's assertion that the evidence is not fabricated, they do not come close to matching the gravity of other cases previously adjudicated by this court, even on a purely statistical basis. We heard yesterday, both from the prosecution and CLRV1, that the low number of alleged child soldiers did not matter, and that the motive of the alleged recruitment also did not matter in relation to the gravity of the alleged crimes. But respectfully, it does matter for sentencing. There is a clear difference where children are abducted as part of a systematic campaign to assist and to be abused by the armed group, to a situation where children were alleged in standing guard at roadblocks or added to a list for fraudulent purposes. So, and with respect to the argument that young age of victims constitute an aggravating factor, we submit, as held in the Lubanga case, that the age of victims is already inherently accounted for as part of the elements of the crime under Article 8.2e, Roman 7. And to consider this factor again as an aggravating factor would risk impermissible double counting. But moreover, even if your honors were minded to consider the alleged young age as an aggravating factor, we respectfully submit that this has not been proven beyond reasonable doubt. There is clear evidence in this case, abundance of evidence, that undermines the reliability of the age of the alleged victims, further diminishing the weight of this claim in these proceedings. And to conclude today's submissions, Your Honor, you will be, of course, alert to the fact that the defense has not proposed a range for sentencing at this stage. And instead, to assist Your Honors, we focused on highlighting specific factual and legal considerations to be taken into account in the event of a conviction. And it's the only chamber who will be able, it's only the chamber, in our view, who will be able to determine the range of sentence once Your Honors makes its factual findings as to the scope of Mr. Yekatom's alleged culpability. And this is particularly the case given the overlap of the prosecution's case concerning the criminal plan and the criminal policy, and the scope of acts attributable to Mr. Yekatom, and the overall intention ascribed to him. And yesterday, the prosecution repeatedly stated that any conviction of charges against Mr. Yekatom would mean that the chamber would found ample evidence on his substantial participation in the commission of crimes, as well as the high degree of intention and knowledge. And this presupposes the Chamber's finding on his degree of participation, which would underpin any conviction, even if he would be found guilty of every single count. This does not take into account the variable scenarios in which culpability could be found, both in terms of factual allegations and alleged individual culpability. And nor does any conviction negate the favorable evidence concerning Mr. Yekatom. But if we go back to the barometer of sentences imposed by this court, we have cases where the degree of harm was far more wide-reaching and long-term, but attracted sentences lower than that proposed by the prosecution and the victim's representatives. For example, in Al-Mahdi and Al-Hassan, whereby sentences imposed 9 and 10 years respectively, and again, not getting into the minute detail, but in essence, cases were found to have discriminated against the entire population of Timbuktu, imposing restrictions that touch upon all aspects of life of the population, and resulted in destructions of mausoleums that had regional and international impact as World Heritage Sites. In this case, and it was emphasized yesterday by the prosecution, they want you to find that the crimes resulted in the multiplicity of victims, with thousands and thousands directly impacted. But the assessment as to the scope of victims for the purpose of sentencing must, of course, be limited to the crimes charged against Mr. Yekatom, found to have been committed by him, or acts of others attributable to him. And this would then, of course, exclude, for example, general crimes allegedly committed by the nebulous anti-Balaka groups. In Katanga, the Chamber imposed 12 years in relation to the attack in Bogoro, which resulted in the intentional killing of at least 30 civilians in the course of the attack itself, and was followed by the targeted pursuit of villagers and the pillaging and destruction of property following that attack. And of note here, and this is what's important for us, the Chamber's consideration of Mr. Katanga's efforts to secure peace in DRC, including, in particular, his personal and active support to the process of disarming and demobilizing child soldiers, which was rolled out in Ituri. You have already heard earlier Ms. Baysat setting out key examples of Mr. Yekatom's considerable and consistent efforts to secure peace in the Lobai and in the Card region in general, both during and after the charged events. Efforts which undoubtedly, to echo the words of Trial Chamber 2 in Katanga, weigh in favor of imposition of a less severe sentence. So today, Your Honors, we urge you to assess the facts of this case individually and proportionally, without being swayed by precedents that bear no resemblance to the matter before you. A fair and a measured sentence must be reflective of the specific evidence and circumstances in Mr. Yekatom's case. And a sentence should not be inflated by unrelated frustrations or by overly broad assessments. And this, Your Honor, concludes the Yekatom presentation. Thank you.
Thank you, Ms. Dimitri. We have now the early and shortened lunch break until 1 o'clock.
All rise, veuillez vous lever.